sitting day, Government Order of the Day number 7.
Sale and supply of alcohol, display of low alcohol beverages and other remedial matters Amendment Bill, second reading.
Speaker.
The Honourable Amy Adams.
Speaker, I move that the sale and supply of alcohol, display of low alcohol beverages and other remedial matters Amendment Bill be now read a second time. Mr Speaker, can I thank the members of the Justice and Electoral Committee for their consideration of the bill. The committee has recommended that it proceed with amendments. The Sale and Supply of Alcohol Act 2012 was introduced to reform alcohol laws in New Zealand. The Act introduced a range of new measures to ensure the safe and responsible supply, sale and consumption of alcohol and to minimise harm caused by its excessive or inappropriate use. That Act has been enforced now for 3 years, and while communities are still in the process of bedding in the new measures, early indications are there that it is making a positive impact. Certain minor and technical issues have, however, emerged which require correction. This bill makes changes to ensure that the Act is operating as it was intended. The changes correct drafting issues that are causing confusion and uncertainty for retailers, licensing communities and the public. They are technical, narrow in scope and do not change the policy intent of the Act. The core change in the bill is to the single area of supermarkets provisions, which prescribe the only area in a supermarket or grocery store where alcohol can be displayed for sale. The purpose of the single area is to limit shopper exposure to alcohol products. Under the wording in the current law, supermarkets and grocery stores that sell low alcohol and non-alcohol beer and wine currently cannot place them for sale in the same area of their shops as regular strength alcohol. This was an unintended consequence of a well-intentioned provision in the Act. When we're trying to promote responsible drinking, it doesn't make sense to separate low strength and non-alcohol from other alcoholic products. Instead, the option of promoting low and no alcohol alternatives should be supported. To address this, the bill amends the Act to allow for the display or promotion of, or the advertisement for, low alcohol or non-alcohol beer, wine or mead in that single area. The second change in the bill is to clarify that a company can hold an alcohol licence under the Act. The Act does not explicitly include a company in the category of who can hold an alcohol licence. While it was not the intention of the Act to include companies, this omission has been causing ambiguity around how a company is defined in the Act. The bill clarifies that a company can hold an alcohol licence by adding company to the list of who can hold a licence. I understand submitters to the Select Committee were in support of this amendment. Mr Speaker, can I now briefly comment on the change that the Justice and Electoral Select Committee recommended to the bill? The committee has recommended a change to the bill to replace the definition of working day in the Act so that a working day does not include a Monday after a weekend containing either Waitangi Day or Anzac Day. This reflects the change to public holidays made by the House in the Holidays Full Recognition of Waitangi and Anzac Day Amendment Act 2003. The change in the bill is minor and technical. The working day definition is relevant to licence application and other procedural aspects of the Act. Mr Speaker, I'm very happy to support the committee's change to the bill, which I think is a sensible amendment, and can I once more thank the committee for its work throughout consideration of the bill. I commend the bill to the House.
The question is that the motion